must be established before releasing that information. Section 2 also directs the Attorney General to adopt rules carrying out the provisions under Section 2. Specifically, the Attorney General will have to come up with the procedures for submitting the written request in subsection 1D. Also, the materials that must be provided to the public body to establish a compelling public interest for that information to be released. It should be noted that if that threshold is in fact met, there is a very limited amount of information that will be allowed under law to be disclosed. That is the name, the age, and the county of residence for the holder or the applicant. It should also be noted that under Section 3, it provides a retroactive clause. This clause is important because currently we have two requests that have been made for gun records on CHL holders. Regarding Section 3, it basically will require and will apply to any pending disclosure requests that are there at this point. I want to note that the bill that was passed by the House that came to the Senate did not, and I'll say again, did not include the retroactive clause. Now, with the B version, we will in fact be able to have those records if they're not produced prior to this measure going to effect, being allowed to not be honored by the requesters. My understanding, those two requests that are pending are for statewide records by the Oregonian newspaper as well as the New York Times. House Bill 4045B represents a reasonable compromise that recognizes the Oregon's public records laws and also recognizes the public privacy rights of individuals who have CHL holders licensed or has applied for one. It also protects sensitive information that could be used for identity theft if it got into the wrong hands. Now, I think it's important for us to go over a few of the provisions that are maintained in the bill as to what is going to be the basis for disclosures. As I mentioned to you first, the first three were ones that came from the House version of the bill. A public body can give to another public body for criminal justice purposes those records. If there's a court order, civil or criminal, if the CHL holder consents to the release of those in writing, then that information can be released. The fourth is the public body determines that there's a compelling public interest. Again, as I mentioned, this will be dictated and worked through the Attorney General process and establishing the process for this to be done. If a victim can demonstrate that they are in fact a victim, they are going to be allowed to make certain and determine whether a person who has been convicted of a crime against them is or is not a holder of a CHL permit. Media may also make similar requests regarding an individual who has been, again, convicted of a crime to determine whether or not at the time that they committed the crime, whether they had in their possession or used a firearm at the time of that crime. The seventh area is dealing with the state police. Now, this is one I want to put on the record as to what the parameters are on this one. The state police currently maintains what is known as the Law Enforcement Data System, commonly referred to as LEDS. The LEDS system currently does provide for a category that says whether or not an individual is a CHL holder. They will be in the process on passage of this bill to remove that information from the LEDS records except for those who have authority and jurisdiction for criminal matters, meaning if you have an agency, Mr. President, that actually would be doing some type of background check, they would no longer, as of January 1, 2013, have access to that column of information because it is not pertinent to that their inquiry regarding a background check. But it needs to be stated that at this point that the seventh reason for this, is limited to those individuals who are currently subscribing to the LEDS records as to having access to it through that process. This is not intended to be a means for someone who does not have authority granted to them to be on the LEDS system to somehow circumvent and get those records. The last one I think is worth noting is that the Judicial Department of the State of Oregon is not covered by the bill for the simple fact that they have so many records, so much information that would have to be redacted that it would be cost prohibitive, and the bill itself would not be able to move forward if we actually required that. This is a bill that Representative Thatcher and myself worked on to make certain that we had the checks and balances in place, and as I said, one that is reasonable compromise that recognizes Oregon public records laws and at the same time the privacy rights of individuals. This bill is in fact supported by the Oregon State Sheriff's Association as well as the National Rifle Association. I understand the Oregon Gun Owners Association is neutral on the bill. Thank you, Mr. President.
We're now in discussion. Recognize Senator Fred Girard.
Thank you, Mr. President. Potential conflict?
Would you please note your conflict?
Colleagues, I have a concealed handguns license. To the bill?
Your conflict has been officially placed in the record. Your potential conflict. Would you please now speak to the bill?
It's nobody's business.
Recognize Senator Burdick, please.
Thank you, Mr. President. A question of the carrier.
Did the carrier yield their question?
Yes, Mr. President.
The carrier will yield.
Thank you, Mr. President. These records have been public for a long time. Can you tell me what specific problems you've seen with these records that instigated this bill?
If the carrier is asking me what personally I've seen, I cannot say I've seen anything that is let's say different from the system we have right now, but what I can tell you as a prosecutor myself, I'm very concerned about my address, my location, and specific information. I believe it's very important that we respect individuals who want to have privacy. It's my understanding and my belief that a person who goes to the efforts to get a concealed weapon permit actually wants to have privacy. They do not want to have this information released. Also, when you look at the applications that's required, there is certain information that is currently required, such as the date of birth of an individual, their home address. Even though it's optional, there is a place for Social Security numbers. Again, as a prosecutor, I know that these pieces of information can, in fact, lead to identity theft. I believe that it is very important that we take every precaution that we can to make certain Oregonians are not being subject to identity theft.
Another question, Mr. President?
Would the carrier yield to a question?
Yes, he will.
The carrier will.
Thank you, Mr. President. The information that you mentioned, the name, address, and date of birth, is also present on voting records, which we all use in our campaigns and elsewhere. Why would this be any different than the issues surrounding voting records?
Thank you for the question. What I can tell you is that there is a process for an individual who wants to have that information limited, can go through their county elections offices to have some of that information limited so it's not as an open public record.
Okay, another question, Mr. President?
Will the carrier answer a question?
Yes, he will.
The carrier will.
If this bill is passed, will there be any way to verify that someone has a valid, unrevoked license for the handgun he's carrying into your office or your business?
In answer to the question, there is a process. If you look under the bill section 2(1)D, there is a test that will be required for an individual who is seeking this type of information. If they can show that they have a compelling public interest for the release of that information, they would be able to get it. It is a step process that they would have to go through.
Thank you, Mr. President. Another question, please.
Will the carrier answer a question?
Yes, he will.
The carrier will.
Under this bill, if a violent abuser has his conviction overturned on appeal for a technical reason, can his victim still find out whether he has a concealed handgun licenses? Can witnesses who testify against him at trial find out?
Mr. President, I believe I heard two questions there, so I'll try to answer the first question. If necessary, we'll go back to the second one. If a conviction is overturned, that is not a basis for being able to seek the information. But again, there are a couple of things that I think you need to keep in mind. Number one, a victim does have a process to go through to determine with a yes or no answer whether the person has a concealed weapons permit. Depending on when they made that request, they would determine whether or not they would be able to get that information. If they made it while the person was, quote unquote, convicted, before, as you stated, somehow technically was absolved of the crime, then they would be able to get it. If it was afterwards, they would not. except then you have the fallback general disclosure under, again, Section 2(1)D that may be applicable depending on the facts that they have.
Thank you, Mr. President. Another question, please.
Would the carrier answer a question?
Yes, he will.
The carrier will.
Can the caretaker or adult child of someone with severe dementia or mental illness find out whether his parent has a CHL, concealed handgun license?
Ask for clarification of the question.
What? 1 second. You recognize, would the carrier answer another question or ask, excuse me?
Yes, I will
Would the carrier
clarify.
would like you to clarify your question. Would you please repeat the question? Thank you.
Thank you, Mr. President. If your parent, you've got a parent who has severe dementia or mental illness, and you want to find out if they have, and you're the child or the caretaker, and you want to find out if they have a concealed handgun license, is there any way under this bill that you can do that?
They would have to be able to demonstrate under one of the 6 provisions as to what would be their basis to determine that. I would assume under the general provision showing a compelling public interest would be the one that they would more than likely need to use, which would be, again, Section 2, sub 1D.
Thank you, Mr. President. Another question, please.
Would the carrier respond?
He will.
His carrier will.
Thank you, Mr. President. You mentioned that public bodies can get access to these records under some circumstances. So could public bodies, including public schools, demand that people show their license, and can they check up to see if those licenses are valid if they come into a school?
Thank you. This bill does not give anyone any authority to demand anyone to do anything per se. They would have the ability as a public body to actually make inquiry that's permitted under the bill under Section 1 or under Section 4, which when I say, let me restate that. Reason 1 being a public body asking for information regarding a individual who may be involved in some type of a criminal justice purpose, or under D, which starts on line 16, again, the general disclosure for a compelling public interest.
Okay, Mr. President, another question, please.
Would the carrier respond to our question?
Yes.
The carrier will.
Your bill makes reference to bona fide media, and the days I was in journalism school, the definition of media has changed drastically. It includes bloggers, it includes alternative newspapers, it includes political party news.
Senator, your question, please.
Yes.
You're sort of speaking to the...
Is it your intent to have, and you said that you're going to do regulations, is it your intent to have a very broad definition of media or a narrow definition of media, and where would you set those parameters?
To the questioner, this is, quote unquote, not my bill, first of all. Second of all, the definitions that are set forth as to the requirements of being a bona fide media or reporter will be determined under, I would say, existing case law, as well as the statutes and the interpretation of those statutes. You should, as someone that has worked in the media, you're probably aware that the Attorney General's office has, in fact, commented and actually has a book on public meetings laws, where they do, in fact, identify some of the news media. We do know in today's world that the type of media and individuals that are part of the media is completely different than what it was 50 years ago. So I would expect in the current times that we have, what may not have been considered a bona fide media person or a reporter in the past would in fact be today. I also would caution that we have had other cases, other legislation in front of the Senate Judiciary Committee regarding individuals who are doing reporting on different organizations and they were held out as reporters. And I would again expect that those type of scenarios would be played out here, and I would not see anything in here that would limit the specific definition to a narrow interpretation of media.
Thank you, Mr. President. To the bill.
To the bill, please.
This bill addresses a problem that does not exist in Oregon. These records have been public since 1973, I believe, when the Public Records Law was passed. There's never been a single documented case of anyone coming to harm because of a records request on these. There have been cases where gun advocacy groups have used the records for marketing purposes. The Republican Party has made requests for these records, so you might say that I'm trying to defend the rights of gun advocates to do their work in opposing this bill. But all seriousness aside, the New York Times recently had a story out of North Carolina analyzing their concealed handgun license records, which were fully open to the New York Times. And they cross-checked them against criminal records, and they found a handful of very alarming circumstances. And the problem here that the New York Times turned up, and it was a page one story, was not the people who got the weapons, but how did they get these permits? What kind of a flaw was there in the system that allowed these permits to go to people with criminal records, sometimes violent criminal records? A similar study was actually done in Oregon about 10 years ago, and it resulted in a report to the governor where somebody got a hold of all the concealed handgun license records from out of the lead system, and they cross-checked them against criminal records, and they found 1,200 cross-checks, people who had both a concealed handgun license and a criminal record. So that started a thorough investigation with the Oregon State Sheriff's Association, State Police, the governor's office, and they produced a report. And they found in some cases the licenses should have been revoked and weren't, or were given not appropriately, and not by any willful reasons that anyone ever found. It just was a flaw in the system, flaws that were corrected after this report came out. That sort of analysis of the 150,000 people who are carrying loaded guns, including into public buildings, can no longer take place if this bill passes. And I understand this bill is going to pass today. My questions and my comments are not issued out of any hostility. I know that I have lost this fight. However, I think it's very unfortunate that we are closing off the potential to improve our public safety simply to address a problem that doesn't exist. And that's why I will be voting no.
Senator Frank Morris and Senator Richard Devlin yielded their time. Recognize Senator Elizabeth Steiner Hayward, please.
Thank you, Mr. President. I'd just like to declare a potential conflict of interest.
Would you please state your potential conflict of interest?
Yes, sir. My husband and oldest daughter both have CHLs.
Your potential conflict of interest is now on the record. Further discussion, please. Recognize Senator Przansky. Do you wish to close?
Thank you, Mr. President. Yes, I need to make a couple of statements. First of all, Oregon is not North Carolina. With the records that are currently open today, we have not seen the problems that the presenter of from Portland and Tigard has stated. And I want to make certain this is very, very clear. The threshold today is basically one that you could say is a balancing test of just straight across the board, kind of a preponderance if you're going to have some type of measure. Yes, under Section 2(1)D, it will now be compelling. That will not shut these records down. It just shows that you have to have a reasonable reason that's a greater level than what is currently could be required for those records to be released. Clearly, if you had a situation that if you could show that someone had a CHL license, was a felon, or 2 or 3 or 4 coming out of the same county, I would submit to you, Mr. President, that you would in fact be able to have a compelling reason to have those records from that particular county reviewed, because it appears from the surface that there is someone is getting licenses that should not be getting that. That would be a compelling reason. And so those records will still be open for public scrutiny. We just are saying the threshold needs to be a little bit higher than what it is today. Lastly, as I stated before, there are particular information on these records and these applications, such as Social Security numbers, date of birth, that are in fact used to commit identity theft. I'm for one to say enough is enough. We do not need that information to be released, and I ask all of my senators here today to stand for Oregonians and making certain where they want some privacy that is reasonable, but still maintaining our public records laws, to vote yes. Thank you, Mr. President.
Question now arises upon the third reading and the final passage of the House Bill 4045. Those in the opinion bills to pass say aye. Those opposed, no. Clerk, please call the roll.
Cruz. Monos Anderson. Monroe. Morse. Nelson. Olson. Przanski. Rosenbaum. Shields. Starr. Steiner Hayward. Telfer. Thompson. Berger. Whitsitt. Winters. Atkinson. Bates. Beyer. Boquist. Burdick. Devlin. Devlin. Dingfelder. Edwards. Ferrioli. George. Gerard. Hass. Johnson. President Courtney.
Yes.
Excuse. Starr. Voting no. Burdick. Dingfelder. Monroe. Rosenbaum. Shields. 24 aye votes.
The House Bill 4045, having received a constitutional majority, is declared passed. The clerk will read the bill.
Senate Bill 1594, relating to weapons on school grounds and declaring emergency.
Recognize Senator Jenny Burdick, please.
Thank you, Mr. President. Senate Bill 1594, our second gun bill of the day, would change Oregon law to make schools truly gun-free. Right now, it is a Class C felony to take a gun into a school, and that includes K through 12, community college, higher education. But there is currently an affirmative defense which functions as an exemption for holders of concealed handgun licenses. Senate Bill 1594 would take away that exemption while leaving all of the other exemptions in the law and all of the other provisions affecting schools completely intact. This bill is important because in order to be truly safe, the fewer guns in a school, the better. Now, I understand all of our emails have been lit up for the past few days, including mine, by people who would argue that, in fact, if you have law-abiding adults carrying loaded guns in schools, the schools will be a safer place. But you have to consider, colleagues, what that really means. What you're saying when you say that is that in a situation like the tragedy that we recently had in Ohio, that if you had a law-abiding citizen open fire, that you would somehow be safer. Now, studies have shown that trained police officers shooting sometimes at very close range hit their targets within somewhere between 17 and 40% of the time. That means they hit something else the rest of the time, more than half the time, well more than half the time. Police officers go through extensive training. They go through simulation training. They go through crisis de-escalation training. They go through hundreds of hours of training to make that one decision, shoot or don't shoot. And they are also trained in proficiency for hundreds of hours. So if they do make the decision to shoot, they can get it right somewhere between 17 and 40% of the time. You take an untrained person, and the training requirements for CHLs are very low. All you can do it online, actually. You don't even have to own a gun. You have to take a gun safety class. These don't belong in schools. However, Oregon is a diverse state. And so there are places in Oregon, schools, that may decide that they do want to have the freedom for concealed handgun license holders to bring their guns into schools. For those schools that wish to do that, the process is very easy. Senate Bill 1594 contains a provision allowing school districts at their discretion to allow the holders of concealed handgun licenses to bring their guns into schools. Now, the gun lobby would argue, the people who've been lining up your email would argue that the schools are safer, but the people who actually work in the schools disagree strongly. I've been working on this issue for several years. Also, I've been following polling for several years on this issue. The polling has never changed. Somewhere north of 80% of Oregonians, and that includes many gun owners, because Oregon is a gun-owning state, so you couldn't get this number without a lot of gun owners there, want guns out of their schools. And the people who work in the schools, the Oregon Education Association, the school administrators, school board members, many of whom are gun owners, hunters, many of them live in my district, want their schools gun-free. This is not an issue that should divide us. This is a common sense issue, and this is an issue that lets Oregon schools, instead of some outside lobby group, decide what really, really does constitute a safe school. And I urge an aye vote.
Recognize Senator Jeff Cruz, please.
Thank you, Mr. President. To the bill.
To the bill, please.
Colleagues, this bill is a solution in search of a problem. Mr. President, I was going to ask a question of the carrier, but the question has been asked over and over and over again in committees that I sit on, and the answer has always been the same. It's been a circular, roundabout way to get to an answer, and the answer they get to when you chase their tail on what they say never gets there. The question is, show me one time in the history of this country where a CHL holder has committed a gun crime on a school campus, and the answer is never. So this bill is a solution in search of a problem. Colleagues, we talk about CHL without maybe really understanding what it is. Documents are important. I'm assuming everybody in this room has a Social Security card. To get a Social Security card, you have to be born and, in most cases, prove that you're a legal citizen in the United States. That's a subject we could go into another time. And you get a Social Security card. To get a driver's license, you have to make those same proofs, plus you have to be of a certain age, and it varies from state to state, but it's 16. And then you have to demonstrate a level of proficiency in operating a motor vehicle. To get a CHL, it's all of those same standards, plus you have to be 21 years of age, plus you have to go through a relatively extensive background check. And then and only then does the sheriff make a decision as to whether you get one. Okay, so felons can't get CHLs. And if you become a felon, in most cases, understanding that people can fall through the cracks in the system, but in most cases, it's revoked. So what we're dealing with here, CHL holders are law-abiding citizens who feel a need for self-protection, that they should have the ability to carry a firearm. And they have been fully vetted. They have gone through training, so they understand a gun. They know how to operate the gun. And quite honestly, not everybody's going to be a perfect marksman. But let me tell you, if I'm going down a dark alley and there's somebody coming at me with a gun, the decision to shoot is going to be relatively simple. Colleagues, is there an issue with violence in schools? Yeah, and what happened just a few days ago is tragic, but I'd want to point out that in most of these cases, the violence in school are by teenagers who couldn't have a CHL to start with. This bill is being done for political reasons. It is a solution in search of a problem. If we want to deal with the violence in schools, this is not the pathway that's going to get us there. This is purely a political move. I urge a no vote on this bill.
Recognize Senator Alan Bates.
Thank you, Mr. President. To the bill. I'm not certain if I should apologize to this body about these two bills, the one we just voted on, the one we're voting on in a few minutes, or thank you for taking them up. These bills are the result of two very real issues that happened in my district. And Sheriff Winters and the Milwaukee Tribune were involved, and the Medford School District was involved in both of these. It split our community. The debate went on for months and still rages down there about these two issues. I believe these two bills will help resolve those two issues. We need clear direction in Jackson County about how to handle these issues in our schools and for our concealed weapons holders in our area. I also want to thank the carrier on this bill for placing in the bill the amendment I personally asked for about the opt-out for some districts, because I believe some districts may well want to opt out. And this is a real issue. In the Medford School District, the issue was a woman who was being stalked by her ex-husband and was so threatened by him that she wanted to carry a weapon onto the campus, and she had a concealed weapons permit. That was the issue, and it was a tough one for the district to deal with. This will give clarity. The district will have authority to make their decisions. I believe it's something that we need to vote on. I think it's a good compromise on both these bills, and I appreciate the Senate in taking them up, and I appreciate whatever vote you take today. Some will disagree with us, some will not disagree with us, and that was a tough vote, especially this one. But I appreciate that we are finally going to resolve this issue one way or the other, and I'm hoping when it goes to the House, it does not die. I hope it goes over there and is passed, so we have clarity in our schools about what goes on and what is allowed. Thank you, Mr. President.
Thank you, Mr. President. I'd like to declare a potential conflict of interest.
Would you please note your conflict of interest?
I'm a member, elected member of the Mount Hood Community College Board of Directors, and if this bill passes, I will have to take a vote on whether or not we want our campus to be gun-free.
Well, the potential conflict of interest is placed on the record. Recognize Senator Fred Girard, please.
Thank you, Mr. President. Declare a potential conflict.
Would you please place your potential conflict of interest on the record?
I have a CHL.
That potential conflict has now been placed on the record.
To the bill.
To the bill, please.
Colleagues, you have the right to defend yourself, guaranteed in the Second Amendment. Every teacher has the right to defend themselves. This is a question of the Constitution and the right to defend yourself.
Recognize Senator Ted Ferrioli, please.
Thank you, Mr. President. Mr. President, on May 20th, 1998, 15-year-old Kip Kinkle was suspended from Thurston High School for being in possession of a loaded, stolen .32 caliber handgun. When questioned about the gun by school officials, Kinkle admitted having bought the gun from another student. He was suspended, pending expulsion from school, arrested, and then released into the custody of his father. That afternoon, he shot and killed his father, and later he shot and killed his mother. The next morning, he went to Thurston High School with 2 hunting knives, a .22 caliber semi-automatic rifle, 2 semi-automatic pistols, and 1,127 rounds of ammunition. Within seconds of arriving at school, Kip Kinkle had killed 2 students and wounded 24 others before being subdued and disarmed by students, one of whom was wounded during that rampage. I could ask, but I will not ask the carrier, would anything in Senate Bill 1594 have prevented the attack at Thurston High School? The answer would be no. On February 22nd in Bremerton, Washington, an 8-year-old girl sitting in a classroom was seriously wounded by a handgun brought to school by her 9-year-old classmate. The gun discharged when a backpack was dropped on a desk. I could, but I will not ask the carrier, would anything in Senate Bill 1594 have prevented the accident in Bremerton? The answer would be no. On February 27th in Chardon, Ohio, a youthful gunman stepped into a school cafeteria and started shooting. 3 students were killed and 1 seriously wounded before the gunman was chased from the school by an unarmed teacher. The gunman was apprehended, but no motive has been established. I could, but I will not ask the carrier if anything in Senate Bill 1594 would have prevented the attack in Ohio and a similar attack in Oregon. Her answer would be no. Fear. What we're discussing here today is fear, and more particularly the politics of fear. I and the President have been fearful about bringing this bill to the floor, fearful about what a vote will do to the body, what a vote on this bill does to this institution, and to all of us in public service, no matter how we vote. We frankly and openly discussed, the President and I, many aspects of politics of fear, including how a yes vote or how a no vote will be used by special interest groups to characterize and sometimes to vilify the service and personal values of our members on both sides of the aisle and on both sides of this question. It is not a well-kept secret, as a matter of fact, the carrier mentioned it, that there's a poll that clearly demonstrates how strongly people will react to this issue if the questions asked are phrased in just the right way, if the issue is colored by fear. If nothing in this or any gun bill will prevent the mindless violence visited on students by deranged individuals, and nothing in the bill or any gun bill will prevent incidents caused by those who, because of their youth or mental state, cannot be held legally responsible for their actions, what good is this bill? We all feel helpless after these terrible incidents, and when we feel helpless, we become fearful. We know, as adults, as parents, as policymakers, we cannot control every situation or safeguard against all injury. And like you, colleagues, I am a parent, a grandparent, and like you, not a day goes by that I don't fret about my children and my grandchildren and what they may encounter in their daily lives. But do the politics of fear offer a solution? When this country was attacked on September 11th, I feared it would be the beginning of the kind of terror that has gripped communities from Lockerbie, Scotland to Beirut, Lebanon. Many of my friends and colleagues felt the same fear. And the politics of fear dictates that from those in public office, there must be a response. Nationally, our response has been the creation of the Office of Homeland Security, with all the bureaucracy and all the regulation it represents. Our lives as American citizens has been profoundly altered, and in my opinion, not for the better. The fact is that those who embrace the politics of fear always seem to come up with the same solution: to ration the freedoms of law-abiding citizens, to limit our ability to pursue life, liberty, and happiness, which lawfully belongs to a free and law-abiding citizen. When I listen to the arguments that we should create this new gun law, one that purports to make schools and public buildings safer, I do not have to ask myself whether or not it will make a difference. As an adult, as a parent, as a policymaker, and as a free Oregonian, I know that it will not. What we have to ask ourselves is this: are we willing to embrace the politics of fear for the sake of making a gesture of reassurance to those who are equally fearful and equally powerless to prevent these terrible and heartbreaking events? And as adults, as parents, as policymakers, and as free Oregonians, are we still willing to make that gesture, knowing that the gesture is without meaning or substance? From the very first, Oregonians have counted themselves among the free peoples of the world, because we've rejected the politics of fear, and instead, wherever and whenever possible, we've expanded and enlarged principles of freedom. That is what sustains us, and ultimately is what is our best protection. Finally, there is this: if I thought this measure would prevent even one of the similar acts of violence against our fellow citizens, I would invite you to pass it. It will not. Instead, my fellow senators, for all the best reasons, I ask you respectfully to reject Senate Bill 1594. Thank you, Mr. President.
Senator Jackie Winters has yielded her time. Recognize Senator Elizabeth Steiner Hayward, please.
Thank you, Mr. President. Colleagues, I appreciate the passion and concern around this issue, and I'm grateful for the concerns that have been raised by many of you, both in favor and against this bill. I would speak to two very pragmatic issues around the question of whether having guns in schools will enhance or decrease the safety of children. Many of the accidents that were referred to by our good colleague from John Day occurred because children gained access to guns that were improperly secured in homes, guns that were lawfully possessed, some of them by CHL holders, and yet were not properly secured. Any responsible gun owner knows, as my family does, that to have guns in the home means securing them properly to prevent children from having access to them. On school campuses, there is not a logical place to secure weapons safely. So were a teacher or other staff member to bring a gun to school for the purposes of self-protection or protection of others, the choices would be to keep that gun in an unsecured location close to his or her person and thereby potentially risk access by a child, or to keep it in a secured location, at which point the possibility of using it for self-protection or the protection of others would be extremely limited. I understand the concerns raised, but I don't think that they're valid, and I do think that having weapons there increases the risk of inappropriate access to these weapons. Thank you.
Further discussion. Recognize Senator Doug Whitsitt.
Thank you, Mr. President. I'll vote no today on Senate Bill 1594 because I support the Second Amendment to the United States Constitution, and I support Article 1, Section 27 of the Oregon Constitution that reads in relevant part, "The people shall have the right to bear arms for the defense of themselves." The people shall have the right to bear arms for the defense of themselves. I will vote no because Senate Bill 1594 functionally preempts Oregon's preemption law at ORS 166.170. By allowing all school districts, 17 community colleges, and 7 universities to decide who can and who cannot carry a concealed weapon on campus, effectively preempts that Oregon statute. I'll vote no today because disarmed citizens are vulnerable citizens. There is no verifiable history of a CHL holder ever hurting someone on a school campus. However, there is a long history, unfortunately, of police protection not arriving in time to stop the tragedies. And when the loss of life has occurred in a school, the common denominator has been that no one there had a gun to stop the carnage. Following the Virginia Tech tragedy, Virginia Tech's Attorney General Ken Cuccinelli said it best when he stated that gun ban policies are, quote, ineffectual because persons who wish to perpetrate violence will ignore them, and the net effect of such policies is to leave defenseless the law-abiding citizens who follow those policies. And finally, Mr. President, I will vote no today because of the procedures followed in bringing Senate Bill 1594 to the Senate floor today. Those procedures functionally eliminated any chance for public input. Mr. President, this is no way to sail a ship of state. I urge a no vote. Thank you.
Further discussion of this measure, which is before us. Senator Burdick, do you wish to close?
Yes, Mr. President, thank you. First of all, colleagues, to address the constitutional issues that were mentioned, I, along with all of us, took an oath to support the Constitution, both of Oregon and the United States. Nothing in Senate Bill 1594 comes even close to violating the Constitution. Article 1, Section 27 of the Oregon Constitution is actually more restrictive in favor of gun rights than the federal Constitution because it clearly states an individual right of gun ownership. The United States Supreme Court in 2008 in the District of Columbia versus Heller decision established an individual right to gun ownership for the District of Columbia. It doesn't apply to states, but it doesn't matter in Oregon because we already have it. But in applying that decision, the Supreme Court, permission to read from written material, Mr. President?
Please, without objection, feel free to do so.
Although we do not undertake an exhaustive historical analysis today of the full scope of the Second Amendment, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. So the Supreme Court left plenty of room for reasonable gun laws, of which Senate Bill 1594 is one. My colleague from Klamath County mentioned preemption. Preemption is a statutory provision that went into law in 1995. This is a revision of the preemption provision, and this actually it follows in the spirit of preemption. The only thing that doesn't follow in the spirit of preemption is allowing school districts to have their own pro-concealed handgun license requirement if they wish. And I think that's an important distinction to make. Colleagues, this bill is not about active shooters. That's what the law enforcement calls one of these horrible worst-case scenarios inside a school. This is not about active shooters. The solution to active shooters is different, and we've had some success in Oregon on some of those solutions through our anti-bullying legislation, through our intervention with at-risk children. Those are the kind of solutions we need to focus on for active shooters. But you do have to ask yourself, what would happen in those horrible situations if you had one or several people pulling their guns to try to bring down the shooter? So the police come on the scene, they see people fallen, they see 2 or 3 people with guns. Are they going to say, okay, please pull out your concealed handgun license so I can tell which one of you to shoot? And this came out after the Virginia Tech shootings. Law enforcement said it would be terrible to have a bunch of people, the good guys and the bad guys, having a shootout, because when law enforcement arrives, they don't know who to shoot. So that's just a practical thing. But this isn't about active shooters. This is about who gets to decide what makes a safe school. And the schools themselves, the parents, the PTAs, the school boards, the administrators, the students themselves. The University of Oregon Student Council passed a resolution in favor of banning concealed handgun licenses from the University of Oregon campus. They themselves, the people who actually work there, attend there, and send their precious children there, have spoken. They want this law. Their testimony has been overwhelming. I've been dealing with this issue for several years. I have yet to have a school board come in and say, nope, we want all the schools in Oregon to have concealed handgun licenses on them. As to the process, we had a public hearing on this bill. It had a different number, had a different name on it, but it was the same bill. And in that public hearing, we had overwhelming support from the school-owning community, from the school-oriented community. The public support for this is very strong. The polling I've seen on this issue is not biased polling. It's very straightforward polling. Do you want them on there or not? The answer is not. Colleagues, the great playwright Anton Chekhov, there are several versions of this quote, but the quote I'll read today is, "If in the first act you have hung a pistol on the wall, then in the following one it should be fired. Otherwise, don't put it there." Colleagues, let's not put it there. Please vote yes on Senate Bill 1594. And I ask for a call of the Senate.
Senator Janine Burdick has demanded a call of the Senate, and she is joined by Senator Diane Rosenbaum. The doorkeepers will bar the doors, and the Sergeant of Arms will attend. Would the clerk please call the roll?
Atkinson.
What? Well, she was joined by Senator Diane Rosenbaum, and did you want more?
Dingfelder.
Senator Jackie Dingfelder, thank you. Would they now, to officially notice, it was demanded by Senator Burdick, joined by Senator Rosenbaum and Senator Dingfelder. Would the doorkeepers please bar the doors, and would the Sergeant of Arms now attend, and the clerk, would you please call the roll?
Atkinson. Bates. Byer. Boquist. Burdick. Devlin. Dingfelder. Edwards. Ferrioli. George. Gerard. Hass. Johnson. Cruz. Modis Anderson. Monroe. Morse. Nelson. Olson. Brzezinski. Rosenbaum. Shields. Starr. Steiner Hayward. Telfer. Thompson. Berger. Whitsitt. Winters. President Courtney.
All members subject to the call are present. The question arises upon the third reading, the final passage of the House Bill 1594. Those in the opinion bill shall pass as say aye as their names are called, and those opposed no. Would the clerk now please read the call the roll?
Modis Anderson. Monroe. Morse. Nelson. Olson. Brzezinski. Rosenbaum. Shields. Starr. Steiner Hayward. Telfer. Thompson. Berger. Whitsitt. Winters. Atkinson. Bates. Byer. Boquist. Burdick. Devlin. Dingfelder. Edwards. Ferrioli. George. Gerard. Hass. Johnson. Cruz. President Courtney.
He's a yes.
Excuse, Starr. Voting no. Atkinson. Boquist. Ferrioli. George. Gerard. Johnson. Cruz. Morse. Nelson. Olson. Telfer. Thompson. Berger. Whitsitt. Winters. 14 aye votes.
The House Bill 1594, having not received a constitutional majority, has failed. Would we go now to recognize, excuse me? They want me to hold on. Recognize Senator Ted Ferrioli, please.
Mr. President, the Republicans would value a 5-minute conversation by the water cooler on another bill.
Okay, Senator Diane Rosenbaum, do you have any request?
No Democrats will stand at ease.
Okay, we'll be at ease here for 5 minutes.